My name is John Hallway. I'm the Executive Director of the Quattrone Center for the Fair Administration of Justice here at Penn Carey Law. On behalf of my colleagues at the Quattrone Center, my colleagues at the law school, it's a pleasure to welcome you all here and to welcome Tom Dybdahl and Christina Swarns to talk about Tom's wonderful new book, When Innocence Is Not Enough, Hidden Evidence and the Failed Promise of the Brady Rule. You may notice that only Tom is sitting in front of me despite the fact that Christina was promised. You can see Christina on the Zoom behind me. Apparently, when there's a fire that blocks out the entire Northeast Corridor and you're north of it on Amtrak, it's hard to get here. But due to the beauty of Zoom, Christina, thanks for enduring and making it through and pivoting and being here with us anyway. We're here to talk about prosecutorial misconduct today. And when the Quattrone Center was founded in 2013, I think that through the generosity of Frank and Denise Quattrone, prosecutorial misconduct was really at the heart of the wrongs in the criminal justice system that cause people to be wrongfully convicted, and therefore at the heart of what they hoped the Quattrone Center would solve as a problem. I'm sad to report that we have not solved that problem. I don't think it's entirely our fault that we haven't solved it, but it remains a vexing and troubling and really damaging issue. There's nothing to suggest that it's happening less frequently than it has been happening for the last 50 years. In fact, since the advent of the Brady Rule in Brady versus Maryland that we'll talk about today, which was in 1963. And a big reason for that is that we don't really catalog it. We don't really count it, and it's very difficult to study. The Quattrone Center released a report in which we counted all of the allegations of prosecutorial misconduct that were available in the Pennsylvania court reporting system from 2000 to 2017. And our study was only the second of its kind. We're not aware of any systematic approach to cataloging, gathering, reporting on, explaining what happens because of prosecutorial misconduct. It took us 4 years to do our study. And as a result, we don't actually really even know the prevalence. We found that of the 7,000 claims, Pennsylvania courts agreed that prosecutorial misconduct had happened a little bit more than 200 times. But since our 7,000 claims all came from 4,000 appellate cases, and since appellate cases generally require a trial, and since only 3% of Pennsylvania cases go to trial, it seems almost certain that the vast majority of prosecutorial misconduct, A, goes uncounted at all, and B, is certainly not systematically collected or reported. In part because of that, it is works like Tom's and his book that become so important in our understanding of prosecutorial misconduct. And so for Tom to bring this together and to tell you about the problems, and in particular to focus on the case of Catherine Fuller in DC in 1984, which resulted in 8 young black men getting life sentences in jail for a case that was rife with evidence that had been suppressed, misunderstood, not turned over, and other errors, is really heart-wrenching and really important for us to understand and keep in mind so that we keep this issue in focus and can continue to learn about it with the hopes of eradicating it. For those of you who are taking this for CLE, I have to take an administrative break and let you know there are 2 words that you need to know to get your CLE credit. The first one of those is open. I'm going to give you the last one at the end. This is how we compel your full participation in the session, other than our speakers, who I'm going to introduce very briefly, and then I'm going to let Tom talk, and then Tom and Christina are going to take it away. So I'm going to start by introducing, and by the way, this is a kind of a especially cool event for Penn Law, because both Tom and Christina are graduates of Penn Law. And it's wonderful to see, not only to have our graduates back, but to see all the good they're doing in the world. Tom, I haven't known for very long, but you can see from meeting him and from talking to him for 5 minutes that he is the absolute definition of a lifelong learner. He has degrees in theology, journalism, and law, obviously the law degree from here at Penn. But he went and got that law degree in his 40s, which shows just what you can do when, at any point in your life when you choose to come get a law degree. Tom actually had performed a 2-year volunteer mission with the Mennonite Central Committee that sent him to Louisiana, where he worked with the Louisiana Coalition on Jails and Prisons, and in particular engaged with death row inmates on helping them get access to lawyers at a time in Louisiana when the death penalty had just been restarted after a Supreme Court decision, and death row inmates were having particular challenges finding counsel. Along the way, he met Sister Helen Prejean, who many of you may know as herself a best-selling author and chronicler of death row and the inhumanities of that system, and the movie, what became the movie Dead Men Walking. She's written a terrific foreword for the book, which I encourage you to read. Tom channeled his appetite for learning and activism into his Penn Law degree, and after that became a public defender. He spent a little time with the Philadelphia Defender Association before moving down to the public defender service in the District of Columbia, where he worked on trial and appellate divisions and tried 25 homicide cases. So obviously somebody who has been a part of the system for quite a while and an expert on both the case that he's describing here and the intricacies of the Brady Rule. Christina Swarns, who you see above me on the screen, is another incredibly distinguished Penn alumna. After getting her JD from Penn, she became a staff attorney for the Legal Aid Society, worked for the federal defender in the Capital Habeas Corpus Unit of the Philadelphia Community Defender Office, then served as litigation director for the NAACP Legal Defense and Education Fund, and was president and attorney in charge of the Office of the Appellate Defender, one of New York City's oldest providers of indigent appellate defense, before her joining her current role, the executive director of the Innocence Project, which obviously is a global organization that has literally changed the way law is practiced, not only in the United States, but across the world. It's also safe to say that without the Innocence Project's work in helping to reveal the truth of wrongful convictions, there would be no Quattrone Center here to try to learn from wrongful convictions. So we're obviously in the Innocence Project's debt, and Christina, I can tell you personally, there was a huge cheer when we heard that you had become the executive director of the Innocence Project. You could probably hear it all the way from New York. So it's wonderful to have you both here. What we're going to do is Tom's going to speak for a little while, and then Tom and Christina are going to speak for a little while, and I'm going to try to take a look at the chat and questions there. And then we'll do Q&A both with people on the Zoom and with all of you here in the room. And then we'll take you downstairs and we'll buy you a couple of drinks. So that's the agenda. And without further ado, let me introduce Tom Dybdahl.
Thank you very much, John. It's a great pleasure to be here. I feel an abiding gratitude, I think, to Penn Carey for taking a chance on a 49-year-old 1L and accepting me. I single-handedly jacked up the median age of the class by about 10 years. But it was a great experience. It led me to a fulfilling career as a public defender here in Philly and also in DC, and now to being a first-time author. So thanks, Penn. And Christina, I should say that despite her extreme youth, she was 5 years ahead of me at Penn. And she was working on death penalty cases as an assistant federal defender when I wandered into her office as a first-year intern seeking wisdom. And she took me in, she shared freely her knowledge and experience, and even brought me out investigating with her to learn about how the law worked in real life. Christina, you've certainly had a stellar career, but I hope you know that you've inspired me and many, many others with your service and your commitment, and you continue to do so. So thank you for being here. And then to all of you in this room and on Zoom, thank you for being here. October 1, 1984 was a cool, drizzly Monday in Washington, D.C. About 4:30 that afternoon, Catherine Fuller, a 49-year-old wife and mother of 6, left her brick row house in Northeast D.C., headed to Family Liquors, a short 10-minute walk away. She never came home. Barely 90 minutes later, a street vendor found her 99-pound body in an empty garage off of a narrow, trash-strewn alley behind the 800 block of H Street Northeast. Miss Fuller had been sodomized with a pipe and kicked and beaten to death for $40 and some cheap jewelry that she wore. It was perhaps the most savage and senseless killing in district history. That's what the police said anyway. Because of the utter brutality of this crime, officers were under pressure to solve it quickly. But the two lead detectives faced a serious challenge. Neither man had spent much time working in the neighborhood where the murder took place. Neither was skilled at working the street. And several searches of the scene, which was the garage and the nearby alley, yielded no physical evidence that pointed to a likely killer. The bystanders who gathered that night had no information, just questions. In the absence of any solid suspects, officers grabbed the first lead they got. An anonymous phone tip. A man said he'd heard a bunch of local guys, supposedly members of a gang called the 8th and H Crew, talking about pulling women into the alley to rape. It was a slender thread at best. The caller didn't say he'd seen or heard anything specifically about Catherine Fuller or about her killings, but it was what the police had, so they ran with it. Within hours, the detectives crafted a theory based on this tip. They surmised that a group of young men from this 8th and H Crew, which was named for the neighborhood's busiest intersection, had been hanging out in a nearby park. They saw Miss Fuller walk past, followed her, and pushed her into the alley to rob. When she resisted, they dragged her into a garage where they beat and kicked and violated her like sharks on a feeding frenzy, as one of the detectives put it. Then they left her to die on a cold cement floor. It was a riveting, unforgettable theory, but solid evidence to support it proved to be elusive. The killing occurred during rush hour on a Monday. H Street was a busy commercial strip, and row houses backed onto both sides of the alley where Catherine Fuller was killed. Yet after hundreds of hours of canvassing, dozens of interviews over the next few weeks, police had not found a single eyewitness who had seen anything related to a gang attack. But rather than considering the possibility that they might be on the wrong track, the detectives doubled down. Officers started picking up every young person from the 8th and H area they could find, some as young as 13, and pressing them with threats and promises. And finally, at the end of November, nearly 2 months after the murder, they got a troubled, not too bright teenager to say that he had stood at the end of the alley and watched while a bunch of neighborhood guys dragged Catherine Fuller into a garage and killed her. Over the next 2 weeks, officers picked up 10 of the young men that he had named. As the arrests mounted and the horrible details of the crime became public, the prosecution wove them into the narrative they had constructed. The gang story captured the public, the media, even the defense lawyers. It was the only story of the killing that anyone heard. It became the accepted truth of what had happened in that alley, long before a single piece of evidence had been presented in a court of law. All of the young men accused of the crime offered the same alibi defense. It wasn't me, I wasn't there. But it was a hard thing to prove. They had been arrested many weeks after the killing. This was 38 years ago, long before cell phones or email or any social media. The defendants were all young. They lived in the neighborhood, they went to the school or the park or the arcade or the carryouts there every day. And it would have taken only minutes to be involved. They knew they hadn't been in that alley when Miss Fuller was murdered, that they'd had nothing to do with the crime. But none of them could remember or account for every action on that fateful Monday. Meantime, the prosecution had its own problems. The police never found any physical evidence linking any of the defendants to the crime. They never found any independent eyewitnesses. All they had was words, manufactured evidence, a mesmerizing gang story supported by the confessions of two teenage snitches who traded their testimony for favorable plea deals. And as the prosecutor struggled to assemble his case for trial, he uncovered some powerful evidence that pointed to a completely different crime scenario, a completely different suspect. The vendor who found Miss Fuller's body had stayed near the garage waiting for officers to arrive. He, along with two other witnesses, saw two young men flee from the scene when the first squad car pulled into the alley. Several months later, all three of them looked at some police photos. They all identified the runners as a 19-year-old James McMillan and one of his associates. And none of them, by the way, had seen a single one of the defendants in the area at any time that day. McMillan was living in a house that backed onto the alley just steps from where Miss Fuller's body was found. He had quick, easy access to the scene. All three witnesses said he seemed to be holding something under his coat as he ran. And the object used to sodomize Miss Fuller was never recovered. And despite his youth, he already had a record of serious violence against women. McMillan was, in short, a highly plausible suspect. Once he learned this information, the prosecutor, Jerry Gorin, knew he had a duty to disclose it to the defense. In the 1963 case of Brady versus Maryland, as John mentioned, the Supreme Court had decreed that in a criminal case, the prosecution must turn over any favorable evidence to the defense. The reason for the rule is simple. Criminal trials are supposed to be fair. A prosecutor's job is to pursue justice. Hiding information a defendant might use to prove his innocence is contrary to that goal. So the Brady Rule required prosecutors to share that evidence. But as you might imagine, the rule has not been particularly popular with them. Now, put yourself for a minute in the place of Gorin, the prosecutor. Fuller murder is by far the biggest case you've ever handled. It's front page news. It could make your career. And you believe, or at least want to believe, that the guys are guilty of a terrible crime. But your evidence is slim. Your star witnesses have told multiple stories about what supposedly happened in the alley. And they are testifying only in exchange for some sweet plea bargains. Then your detectives find this compelling evidence pointing to McMillan as a possible killer. But he doesn't fit with the gang theory. He's a loner, he's new to the area, he doesn't know the locals. If he's the killer, the gang story that you have been pushing is false. 17 people you've arrested are innocent. After all the publicity, all the claims of having solved this horrible murder, you'd have to admit that you'd been wrong from the get-go. Gorin knew that if he followed the Brady Rule and disclosed this information about James McMillan, he would give his opponents a ready-made defense, a defense far stronger than their flimsy alibis. They could, with good reason, say McMillan was the killer. He could easily lose the trial of his life. So he buried the evidence. It was easy, and the defense never knew about it. After a 5-week trial in late 1985, the jurors deliberated for 9 full days. Many of them were troubled by the government's case, by the heavy reliance on the 2 snitches. They were looking for other possible scenarios, other plausible suspects, but they had no crime story to consider aside from the official gang theory. In the end, under heavy pressure to resolve the matter, the jury convicted 8 young black men. They were all sentenced to life in prison. The case seemed finished. The information about James McMillan would likely have stayed hidden forever without the work of an intrepid Washington Post reporter named Patrice Gaines. In the mid-1990s, she and a colleague dug into the old files and interviewed many of the Fuller case participants. Because of her work, the Mid-Atlantic Innocence Project, which is an affiliate of Christina's organization, took over the case, and lawyers working with them uncovered the evidence about James McMillan that the prosecutor had hidden, along with other new information that further undermined the gang theory. They also learned that 8 years after Quattrone Fuller's killing, shortly after his release from prison for 2 robbery convictions, McMillan committed the vicious rape murder of a young woman in an alley near 8th and H Northeast. And he was now serving life without parole for that crime. Armed with this previously hidden evidence, the Innocence Project lawyers did win a new round of appeals for the men and a 2017 hearing before the Supreme Court. But because of the sad state of Brady Law, they did not prevail. A majority of the justices said the evidence should have been disclosed, but they concluded it was too late and too little to have likely changed the result. The Quattrone Fuller murder case is a textbook illustration of why the Brady Rule has not worked, why it can't work. It asks prosecutors to disclose information that hurts their side and helps their opponents. And since they control the evidence, it's something they can easily avoid doing, something that often remains unknown. And it's also something that, if discovered, is seldom punished by the courts. As a public defender, I saw prosecutors regularly violate Brady. And when they did, judges mostly shrugged. That's all too common. The National Registry of Exoneration says hiding favorable evidence, breaking the Brady Rule, is the leading cause of wrongful convictions in the U.S. Of 2,400 documented exonerations between 1989 and 2019, Brady infractions helped to convict 44%, 1,056 innocent people that we know about. I wrote When Innocence Is Not Enough to focus attention on the Brady problem, to explain the rule's history, to detail how it has failed, and to show why we desperately need reform. In the last section, I argue that the best decision is to, that the best solution is to take decisions about disclosing evidence out of the hands of prosecutors who will always be conflicted about sharing favorable information. We need legislation that requires them to disclose their entire investigation files to the defense, a policy called open file discovery. And 2 unlikely states, North Carolina and Texas, have done that with remarkable success. And as we discuss this issue, it's important not to get lost in mere academic and policy arguments. Every Brady decision a prosecutor or a court makes is about someone's life. Every ruling decides someone's fate. The human cost of Brady's failure has been enormous. Hundreds of people wrongly convicted, an untold number of lives damaged and destroyed. In the interest of fairness, in the name of justice, we must find a way to make Brady's promise real. And there's no better person to explore that issue with than Christina, whose work with the Innocence Project has involved hundreds of cases of Brady violations, and whose mission is not only to help those individuals, but to address the systemic problems like those with the Brady Rule that perpetuated justice. So So Christina, why don't you tell us a little about your experience with Brady before we dive into some of these issues?
Thank you, Tom. And thank you to John and the Quattrone Center and to Penn Law School. It's always a privilege and an honor to come back to the school that I attended for 3 years. And it's a pleasure to be here with you, Tom, because I also remember working closely with you when I was at the Philly Federal Defender. And as you all can now see, Tom, even then, was a man of grace and integrity and real rigorous thought and attention and close analysis to the cases. So it was really my privilege to work closely with him even then. So as John mentioned, the Innocence Project was founded in 1992. I graduated from law school in 1993, and the first job that I had was as a trial public defender in New York City. So I have a clear sense of what the world was like before the Innocence Project. At that time, the Innocence Project was sort of an idea, right, by Barry Scheck and Peter Neufeld. This revolutionary thought that maybe, just maybe, DNA evidence could prove, science could prove what public defenders felt like they were seeing every day in the courts, right? Be able to penetrate assumptions about the evidence that was being presented and show scientifically whether or not the people who were being convicted in courtrooms, who were taking pleas in courtrooms, were or were not actually guilty. And so this was the experiment that the Innocence Project started. And at the time, there was really very little skepticism about the effective functioning of the American criminal legal system. The broad assumption was that this was the finest system in the world, that the people who were being processed through it were being processed through it for very good reasons, and that those who were convicted belonged in prison. There just wasn't a real understanding of the difficulties and the problems that is now sort of commonplace for us today. But what changed, right, the way the world operated was the emergence of these DNA exonerations. One after another, all of us that were practicing at that time and all of us in the country saw largely men, right, emerging from decades behind prison, after DNA proved that they were not guilty of crimes for which there was all manner of other evidence against them. Eyewitnesses, like Tom said, people who were informants, right? All kinds of evidence, confessions, right? All this evidence was presented against these gentlemen, but the DNA evidence proved that they were innocent. And so one after another, an astonished nation watched as people became proven to be innocent. And so the project of exonerating people through DNA was obviously important because it freed people who didn't belong in prison in the first place. But more important from that, really was what it showed about how the system was and was not working. And it it disclosed an enormous amount of flaws. This introduction of DNA exonerations into the system really shone a light on a variety of ways in which the system was not functioning properly, right? It showed the flaws in identification testimony, how easily that people can get it wrong, right? In 1992, we didn't have an understanding of how easy it is for people to misidentify other people. We didn't have an understanding of, sort of the phenomenon of own race bias, right? That we're all best able to identify those of our own race. The exoneration showed, right, that people, in fact, do confess to crimes they did not commit, right? That was unheard of at the time. But it also showed, shockingly, right, that prosecutors were withholding evidence of innocence. It's one of the factors that was uncovered through the streams, case after case of exoneration. So the majesty of the Innocence Project was not only did it commit to doing individual representation, it committed also to sort of understanding, to tracking those cases, understanding what were the causes of those convictions, and then setting about, charting a path to do reform, right? We wanted to not only free people one by one, but doing that by itself would make no sense. So we also it was equally important for the organization to commit to identifying what was causing the wrongful convictions in the first place, and then addressing those issues. And so as an organization, it became clear, right? Identification was a problem, right? So we endeavored to fix those things. We learned that false confession is a problem, right? We endeavored to fix those things as well. But we also recognized that prosecutorial misconduct was playing a huge role in these cases. And it was incumbent upon us as an organization, right, to invest and to understand and to start to work to address that problem in the criminal legal system if we were to succeed in our goal in preventing wrongful convictions in the first place. As Tom mentioned, right, these are cases, unfortunately, we see prosecutorial misconduct cases all the time in the Innocence Project. Just last year, in June of 2022, a client of ours, a gentleman named Mallory Nicholson, was exonerated after he was convicted of the sexual assault of 2 children in Texas. This was an identification case. The 2 young victims identified Mr. Nicholson, and he wound up being convicted after trial, even though he had an alibi, which is that he was actually at the funeral of his wife with family members, obviously, who were with him. What happened after we got involved, we partnered with the Dallas DA's Office Conviction Integrity Unit, who agreed at our urging to sort of jointly reinvestigate the case with us. And when we started digging into the case, what we uncovered, just like in the Fuller case, was shocking hidden evidence of Mr. Nicholson's innocence. First and foremost, we uncovered evidence that the children who were the victims of this crime identified somebody else immediately after the crime took place. They indicated that the person that attacked them was a 14-year-old, and they named this person. They used his nickname. That accusation was not just in the initial police report, it was in 5 police reports. It wasn't just in police reports, it was in the medical examination that was conducted by a doctor after these young boys were examined. So there was all of that evidence, of course, never saw the light of day before Mr. Nicholson's trial. The prosecutor in the case withheld it. Mr. Nicholson went to trial with the young boys accusing him as the perpetrator, and that's how he was convicted. To the credit of the Dallas County District Attorney's Office, once that was uncovered through the joint reinvestigation, they conceded that there was a Brady violation and that the evidence should have been turned over and that Mr. Nicholson's conviction had to be set aside. The prosecutor, the trial prosecutor in this case, and I'll quote him, said that because of his practices and understanding of Brady at that time, it's likely that any information about the 14-year-old suspect was ignored or not provided to defense attorney. That was his understanding. And that's how he proceeded in this 1982 case, so contemporaneous to the case that Tom was talking about. So fortunately for Mr. Nicholson, we were able to exonerate him, but not until after he spent 19 years in prison, and then 21 years in prison, and then another 19 years as a registered sex offender. And this is just one of many examples, just like the Fuller case that we see in the Innocence Project. Like Tom said, almost half of exoneration cases, as the National Registry has noted, involve concealment of exculpatory evidence by prosecutors. And I will note that the registry sort of looked at both prosecutors and police, right? They said, who is withholding the evidence, right? Is it prosecutors or the police? And it was really prosecutors in 73% of the cases involving government misconduct, as opposed to the police that were withholding the exculpatory evidence. So this is a phenomenon that we deal with every single day as we evaluate the requests for representation that we receive, as we do DNA testing, as we demonstrate innocence. Time and again, we are seeing instances of prosecutorial misconduct, specifically through the withholding of exculpatory evidence. The last point I just want to make about this is that it's, withholding this evidence is devastating, obviously, to the people that we represent, because they lose decades of their lives to prison and the trauma associated with a wrongful conviction. But equally horrific is the reality that while our innocent clients are incarcerated, right, the real perpetrator is on the street. In the cases that we have litigated at the Innocence Project, 99 additional violent crimes were committed while our innocent clients were incarcerated, right? So while the folks we represent who didn't commit a crime were in prison, right, the real perpetrator is left on the street to commit an additional almost 100 violent crimes. And additionally, through the work of the Innocence Project, 84 actual perpetrators were identified through DNA testing, right? 84, we have 241 exonerations. And through that process of exonerating those folks, we've identified the real perpetrator in 81 cases. So the withholding of exculpatory evidence is devastating, again, not just to the people who we represent who are wrongfully incarcerated, but also to the people who become subsequent victims. And there was one similarly in Tom's case, right? Because the police and the prosecutors focus improperly on our clients and don't give a fulsome review of the evidence that's presented to them. And we will talk a little bit, I think, about sort of cognitive bias and the other reasons why prosecutors sort of get single-mindedly focused on individuals. But I'll turn it back over to you now, Tom.
Thanks, Christina. Can you all hear us with the microphone? Tom, you want to test your mic?
Sure. Can you hear me all right?
So thank you for that great summary of the Fuller case and investigation. And Christina, thank you for explaining just how widespread they are and how difficult it can be to secure these exonerations. Let me ask this question of both of you, and we'll start with you, Tom, and then Christina. Talk a little bit about what exculpatory evidence is under the Brady Rule. You describe in the book the sort of evolution of Brady from the 1963 decision to now, and what information counts as exculpatory, and how do we know, if you're a prosecutor, how do you know that information is exculpatory, and how do you know of the obligation to turn it over? Like what information you're required to turn over?
Right, that's really a tough issue, and it's easy, we always blame prosecutors for this, but they're in a tough position because the Brady Rule, when William Douglas, Justice Douglas, introduced the Brady Rule, he had never tried a criminal case. He never worked in criminal law, but he had this idea, we need to have a fairer system, so we should have more of a, he actually wanted sort of a joint search for truth. And let's cooperate, let's share evidence, and then we'll reach a just result. Well, the system was deeply adversarial then and now, and that notion, in fact, neither side really wanted particularly to work together. Defense lawyers were happy to have an obligation on prosecutors to turn over evidence. But the idea of working together was alien. And Douglas never defined what the Brady Rule itself says the actual words are, that the prosecution is required to disclose evidence that is material to guilt or punishment. Now, most commentators think what he meant by material was relevant, just something that's relevant to guilt or punishment. But the way the courts interpreted material has become an absolute morass. That they tried to define what is material, and they couldn't define it. What they've done is given out an outcome-based determination, that they say Brady evidence is material if there is a reasonable probability that it might have changed the result. Well, you don't have to be a lawyer to know how slippery and malleable that is. I mean, a reasonable probability it would have changed the result. I mean, if Jalen Hurts hadn't fumbled during the Super Bowl, is there a reasonable probability the Eagles would have won? I mean, you could argue that forever. So The problem, and you can blame prosecutors for not knowing, but what does that mean? Even the courts can't agree on whether evidence is material. And we're asking a prosecutor before a trial, before he probably knows even maybe the defense theory, to decide if some piece of evidence could affect the outcome of the trial. It could never work. I mean, even judges with hindsight, with the entire record, with discussion for months, they end up disagreeing. So when you ask what is Brady evidence, in theory, it's still anything that's favorable to guilt or punishment. And the court has said, you know, obviously it's evidence maybe of another perpetrator, but it's even any evidence that, say, a witness has received benefits or has lied in other cases. It's evidence of misidentification. You know, you could, the courts, in terms of saying what could be Brady, it's not a big problem. What the problem is whether it's material. And for example, in the Fuller case that I write about, they said this evidence about James McMillan was certainly favorable. It certainly should have been disclosed, but we can't say finally 30 years afterwards, by the way, that it would have changed the result. So no harm, no foul.
Well, I think the other thing that the materiality standard does is, of course, when a judge is looking at answering the question of is something material, should there be some sort of new trial or something done, you've really taken the judgment of the jury, 12 people, and you've replaced it with one person, the judge. And Christina, do you know off the top of your head what the rough percentage of judges are that were prosecutors versus defense attorneys?
I don't know the percentage. I know it's not close from one to the other, right? It was only this, you know, since the Biden administration has made a substantial effort to appoint public defenders to the bench that, you know, there's been any significant, not even significant, there's any meaningful numbers of former prosecutors, certainly in federal courts, but the state courts are the same. The numbers are, you know, deeply lopsided. That the majority of judges, to the extent they served as either public defenders or prosecutors, are prosecutors, were formerly prosecutors. The only thing I was just going to add to the prior discussion, you know, about what is exculpatory evidence. I just want to go back to where Tom started, which is just to say it's really important to emphasize that, you know, I think the point of the ruling was also about the role of the state, right? And what is the actual responsibility and duty of the state in a criminal case, right? It's not just to be an advocate in an adversarial system. The duty of the state is supposed to be that it has a different responsibility than even the defense, right? It has an objective goal of, as Tom mentioned, right, of achieving justice, of achieving the truth. So if that is the case, and that is the oath that every prosecutor does take, you know, there's something very fundamentally wrong with, you know, proceeding just with winning as an objective, and, you know, intentionally withholding evidence that would prevent you from winning.
I want to just pause and acknowledge one question that's been put in the chat that I don't think those of you who are in the room can see, but it comes from a retired federal prosecutor who points out that the case that you described, Tom, and some of the cases, Christina, that you're describing are particularly egregious cases of Brady, and acknowledges that there are some of these cases that do exist, but that to call Brady prosecutorial misconduct may not always be accurate. And part of the reason I want to pause and say this is because it has to do with the Quattrone Center's report in Pennsylvania. There was some controversy when we released the report about whether or not we were using the term prosecutorial misconduct accurately. And I think as a literal case, prosecutorial misconduct is a phrase that's defined by the courts, and it's when a prosecutor is engaged in conduct that is deemed to be, you know, in violation of one rule or another. So improper cross-examination, overzealous closing, these are forms of prosecutorial misconduct, right? And that term doesn't necessarily connote a malicious intent, right? And so I just want to, for people who are concerned about the use of that phrase, that is the legal term for a Brady violation, right? And the term prosecutorial misconduct should not necessarily, I think, be used to connote intentional misconduct. In your case, however, with the attorney that you said made a conscious decision not to choose the issue, I mean, I think that's the situation we were dealing with, right?
Yes, and I absolutely agree. I think part of the problem with Brady, again, as I mentioned, a prosecutor has to make a prospective decision, often without knowing anything about the defense case or how things will play out, and that's a difficult challenge. So there are certainly a significant number of Brady violations that are inadvertent. Even conscientious prosecutors can miss evidence. I think the bigger problem with Brady is that even, so that even conscientious prosecutors violate it, but that it's so difficult to define it that prosecutors, and I think, for example, in Gorin's case, in the Fuller case, you can say, well, how could the prosecutor do that? I don't think he was corrupt. I don't. I think he believed in his case or wanted to, and because the definition of materiality was so kind of vague, is that he could figure out a way to justify it to himself. Because at the new trial hearing, this was some 25 years later, he was asked, so why didn't you disclose this information? Isn't it obviously Brady information? And he said, well, it was a gang attack. So any information that it was only a single perpetrator wasn't relevant. So you can see the problem, and something that we often encounter is sort of this tunnel vision confirmation bias, is that he was so wedded to his gang theory that any evidence that didn't support that, by definition, was irrelevant, and therefore he could lawfully conceal it. He didn't see himself as deliberately hiding Brady evidence, and I just hope it won't ever come out. He wanted to win his case, and he thought this was the way to do it.
Well, and another way that misconduct can happen and not be the fault of the prosecutor, the Supreme Court has said in Kyles versus Whitley that information in the possession of the government, it is the responsibility of the prosecutor as an officer of the court to bring forward. That includes information in the hands of the police,
Right.
even if the police haven't turned it over. So this is another example where the structure, and the court has basically said, this is where the obligation rests with the prosecutor. Prosecutors, I think, very fairly might say, I asked for all the information, I didn't get it, what am I supposed to do? Nonetheless, as a matter of law, that's a violation of Brady and prosecutorial misconduct.
Right, I get blamed for something that I had nothing to do with and no control over. I think there was a question here.
Can I ask a question?
Sure.
I don't think this needs to be as complicated, the discussion of materiality, as I've heard it discussed for many years. I am currently a prosecutor. I was formerly a defense attorney. I think the proper view of Brady, and this should be the obligation of all prosecutors, if it hurts my case, I have to give it. If it doesn't hurt my case, I don't care if I give it. Whether there's a ruling later down the road before a court of what's relevant is a separate issue. It's so simple. So could I just follow that up with this? I don't see, and maybe you'll tell me, how legislation will change the, I think your view of that, Prosecutor Gorin, is extremely generous, and that's very nice of you to have that reasonable doubt. I don't really hear that, but okay. But I don't see how legislation is going to change the practice of prosecutors who think, well, this isn't material. I mean, so are legislators going to be going through files? Are there going to be criminal consequences for prosecutors who don't disclose Brady material? How does it work in Texas and North Carolina?
So let me repeat the question for the people who are on Zoom, because I don't think that our mics are picking you up. I'm gonna summarize it, but let me know if I misstate. The questioner is a former defense attorney and prosecutor who asks how legislation is going to solve the issue that materiality ought to be, if it hurts your case, you should disclose it. And the question is, how does the legislation in North Carolina and Texas reduce Brady violations? Is legislation really the answer to the problem?
Sure, and I think the first half of what you said is right. I mean, we always said to a prosecutor, if you don't want to disclose it, it's probably Brady, and you probably need to. And if Gorin had applied that, obviously he would have disclosed it. He fought, in fact, in open court to keep it hidden. As to your question about legislation, there's a couple ways I think that it really helps. One is that the law simply says open file discovery. So whatever you have in your file, you disclose. You don't even have to think, is this favorable, is this unfavorable? You just say, if this is part of my case file, I turn it over. Now, obviously, it's always people doing it, so if there's someone unscrupulous who wants to hide stuff, they'll still do it. And for example, in North Carolina, they first said, well, anything in the prosecution's file has to be turned over. So then the police started withholding evidence, not giving it to the prosecutor. So then they had to expand that. I think why I propose that is I think Brady is basically hopeless. As long as prosecutors are making disclosure decisions, they're going to be conflicted, there's going to be issues. If we just say everything in your file goes over, that's clear. If they want to hide something, then they know they are breaking the law. Whereas in other cases now, prosecutors can say, I don't really think this is Brady, so if I withhold it, I'm not doing anything wrong. If the law says disclose everything, they know if they're breaking it. Is it perfect? No, and nothing will be. But I think it has proven to work, and North Carolina is a great example. There was a study done of prosecutors and defense lawyers some years after, and it turned out that after all the cries of this will ruin the system, witnesses will be found and killed, trials will be subverted, there actually was a much better spirit of cooperation. There were more plea deals because there was pre-plea disclosure. There were better working relationships, and both prosecutors and defense lawyers felt the system was fairer and more transparent. Now, it's no miracle, it took a lot of work, but I think it's possible, and I think it would be a giant step forward over the current Brady mess that we have.
So Christina, let me ask if you want to chime in on that, and let me append to the question and say, in a situation where legislation isn't passed, what are your thoughts on what we can do to improve the system in that instance as well?
Well, let me answer that question first. You know, at the Innocence Project, we've advocated for, you know, a variety of reforms around Brady to address the problem of Brady non-disclosure, including having sort of standing Brady orders. In New York, for example, you know, we have a standing, there's now a standing Brady order that governs every single court, right? And it just lists everything that has to be provided by the prosecutor, you know, so there's no confusion, right? There's not judgment calls that have to be made. It's, you know, it's police reports, it's exculpatory statements, whether oral or written, it's impeachment evidence, right? It's sort of a very specific, you know, order issued by the court that lays out with specificity every single piece of paper that has to be turned over to the defense. And so that's something short of legislation that could be done, right? That could be done, I think, to improve things. The other thing, though, I would want to just step back and say, which goes back to your comment, John, about sort of what's the prosecutor to judges ratio, prosecutor to defense lawyers ratio as with respect to becoming judges, which is that, right, the incentives, right, for prosecutors, right, everybody wants to win, right? You want to win your case. And especially for prosecutors, right, winning your case gives you access, right, to these wonderful other opportunities, most notably judgeships, right? It's sort of this record of success in the courtroom of convicting people, right? That gets you the access to these other opportunities. It's not, on the other hand, right, I dismissed, you know, all of these cases, and I disclosed all of this Brady evidence that are considered markers of success for a prosecutor. So I think there's also just sort of a structural incentive system that needs to be addressed, right, to get us to the place where people don't feel the obligation, right, to withhold exculpatory evidence, right? You want to incentivize people and prosecutors to function, in a way that the truth is more important than sort of the win. And so I also just think that there is a structural issue in terms of the way we function as a legal community.
Right, and if I could just add, I mean, obviously in the Fuller case, after the government won, after Gorin won, there was much celebrating and excitement, and it was wonderful that, you have this incredible future ahead of you. You've done this, and dream about the day when the head of a prosecutorial office would call in his lawyer and say, "Great job today, you disclosed this Brady evidence and the jury acquitted this client, and really good work. I'm going to promote you. I'm going to, tell this story." It's just not the way it works, and I think that culture does have to be changed.
Actually, there was the former district attorney in Harris County had an award for the best withdrawn case to try to create that kind of culture. She was not reelected, but I'm sure that wasn't the main reason why. So we have about 5 more minutes left. If there are other questions in the room, we can, yeah, sir.
Propose a solution of open file discovery. Let's assume we now have that system. Let's assume it applies to both the prosecution file and the police file. Have you given any thought to the problem of possible evidence that's not in either file, that's out there? And in the world of electronic discovery, you should know, we should know, that there's a whole lot of stuff out there. So have you given any thought to how to deal with that problem? Having prosecutors turn over stuff that is not in their possession and that they don't even know about. Have you given any thought to that? And if you have, tell me.
So the question being asked is whether anybody has had, or either of our panelists have considered evidence not in the possession of prosecutors or police, but nonetheless out there that has exculpatory potential.
I mean, I don't really know how to answer that. The answer is I don't know how you find that. I would hope that in a place like, say, North Carolina, where it's an evolving system, or somewhere else, that at some point, if that evidence ever surfaces, you figure out where was that, and can we amend the law? Can we broaden requirements either way to include that? But I think, there's always human error in any system, and certainly open file is nothing magic.
Let me propose a partial solution, because this is something I did. I'm a retired federal prosecutor. In our office in New Jersey, we developed a checklist, an extremely detailed checklist of possible impeachment material called Giglio material. Right. As you know, Giglio is a case that basically followed Brady and said you have to turn over impeachment material. That list contained at least 40 items, and it went to every prosecutor in the office. And it contained a lot of things that were not in the police file and were not in the prosecutor's file, but you were now on notice that those are possible things and you had to look for them. Think about whether that could be done in the area of Brady also. And if you can put it in legislation, of course it can't be complete, but 40 things is better than 0 things. And as we went through this, that list got modified. So when social media came out, guess what got added to the list? Facebook stuff. Okay, so you can do this. You have to want to do it, and you have to understand it's never going to be perfect. But I'm just encouraging you to think outside the box, because that's what we did.
Can I just jump in and just say that I think that's wonderful, and I also think that it's really important for prosecutors' offices to have internal accountability systems around these issues, right? Which I think is not. Well, the numbers suggest it's not as robust as it could, would, or should be, right? So I think that's another way of moving the bar forward, right? There has to be, right, as Tom's book he talks in his book, right? People game the system partly because there isn't any consequence for gaming the system. And John, the Quattrone Center report documents really, clearly sort of the difficulties in sort of accountability structures for once there, are Brady violations, right? The consequences are rare and few and far between. And so I think another issue for this conversation is, if there is literally no accountability for the failure to comply with Brady, right? What incentive is there to do it, right? You're just relying on people's best angels to do it in many ways.
Right, and the classic words of ex-Judge Kozinski, prosecutors don't care about Brady because judges don't make them care.
Well, and not just judges. One of the things that, so in 1976, the Supreme Court passes a case called Imbler versus Packman. It provides absolute immunity for prosecutors acting in their role as prosecutors, which means that even if there is an intentional Brady violation, these prosecutors can't be sued in civil court. There are criminal sanctions that are theoretically available. For example, evidence tampering is a crime, right? Even if you're a prosecutor. But then you're asking prosecutors to prosecute prosecutors. And when the Supreme Court issued the Imbler decision, they said, well, we've got the criminal law and we've got the bar. We've got ethics rules. Well, when we looked at the 700 cases of disciplinary conduct that had happened in the 15, 16 years that we did the study, exactly 6 of them involved prosecutors. 4 of them were of the DUI variety and not involving their conduct as prosecutors. And so the bar simply isn't addressing that. Now, the Pennsylvania bar has issued new rules to talk about this, but it remains to be seen how those rules are going to be enforced. So at least with open file discovery, to your point, we now have something that makes clear that you can't masquerade as ineptitude when you are being, intentionally withholding evidence, but we still have an accountability problem.
Yes. And you can also use good faith as an excuse if you withhold something. But yes, there's always the human element, and that's what makes it tough.
So we have time for one more question,
Okay.
and then we'll wrap.
Thank you. So I'm going to play devil's advocate, and as you know, Brady is a trial right, and it doesn't extend to the 98% of convictions of people who plead guilty, and the Supreme Court has said that for exculpatory impeachment or giglio evidence, you don't have to turn over that information to the defense. So when I think about discovery reform, I think what we really need to talk about is with people who plea bargain, and not so much the Brady right that really only attaches to the trial. In a way, one way to look at it is that the people who have the Brady right, who go to trial, are pretty fortunate. Because I'd like to think that even though we don't know the exact numbers of prosecutors who are withholding Brady material, I'd like to think more of them are being honest and not committing misconduct and turning over that material.
So the question is basically, Brady has been developed or called by the Supreme Court a trial right, and so shouldn't we be focusing on enhancing Brady disclosures prior to the 98% of cases that are pled out? And isn't it possible that actually the cases that go to trial are getting better Brady results, as scary as that may seem?
Well, it's true that and by the way, Brady, the case itself never said this rule only applies to trials. It's one of the ways the Supreme Court has severely restricted Brady by saying it is a trial right. And there was one case, probably as you know, Diaz case, where the court reaffirmed that. However, with open file, the difference is that in both Texas and North Carolina, they are required to have open file pre-plea, which does solve that problem. And I agree that if we can't get rid of Brady, it absolutely should cover pretrial, because that's where 97, 98% of the cases are resolved. And it's interesting that in North Carolina, where they've studied, there are a lot more pleas now that people know more about the evidence against them, a lot more informed pleas and probably fairer pleas. But yeah, that's an enormous problem with Brady. But the court is adamant that, we don't want too much justice. So we don't want, if people are going to plead, we don't want them to know anything about the case against them. bad.
Christina, anything you want to add there?
No, I would just amen to what Tom and the questioner raised. Yes, absolutely. It would be wonderful to have Brady before plea. What I will just add is what we know unquestionably from the experience of the Innocence Project, that, innocent people plead guilty for lots and lots of reasons. I'm sitting in a jurisdiction, New York City, where we have a small jail crisis, right? So I know, right, every single day, right now, right, people are pleading guilty to avoid, the specter of spending any time on Rikers Island. So any way I think that we can give people real meaningful options and have a clear sense of their, the case in front of them, it's better, right? It's going to be more efficient at the end of the day. It's going to save money in terms of incarceration time or pre-trial time, trial prep time. So I just think there's, I think it makes sense. Agreed. Makes sense.
So I want to thank you, Christina, for persevering through training challenges. I want to thank you, Tom, for the book. And I want to end with one final note. I recently got to hear a talk from David Brooks, the New York Times columnist who's written about morality. And he said, when he talks about the subject of his book, he said, nice people compliment the book, smart people read the book, and moral people buy the book. So the book is for sale outside.
Buy the book.
Thank you very much, everybody.